Next up, property appraisal fraud in support of property loss claims has become commonplace, leading to inflated awards caused by complicit appraisers and unwittingly aided by some courts. Our next speaker, trial lawyer Mike O'Donnell, chairman of Wheeler Trigg O'Donnell in Denver, will discuss his firm's success in vacating a $10 million loss appraisal for failure to disclose cozy relationships between Property Owners Council and an appraiser, as well as his firm's efforts to impose sanctions. Please welcome Mike O'Donnell.
Thank you. Good morning. So, what the hell is our subject today? Florida has not experienced a major hurricane in over 10 years. And so those lawyers and public adjusters who made their living on the hurricane losses and roofing claims, et cetera, in places like Florida, Texas, and other places have now switched to some extent over to hail. So $54 billion has been paid by insurers over the last, the 14 years, 2000 to 2013. It's even worse in the last couple of years. 30% of that was 2000 to 2006 and 70% between 2007 and 2013. So the severity of the claims has been increasing dramatically. In Colorado, the 22nd biggest state in terms of population, with under 6 million people, is the second worst. Why is it the second worst? Because public adjusters is a growth industry in Colorado. Why is that? Because Colorado has one of the worst statutes in the country. If a property damage carrier does not pay timely or denies benefits that a court finds should have been given, they can be liable for bad faith. They can get, the penalty is 2 times, up to 2 times, the differential between what they offered and what has been found to be fair, plus attorney's fees and costs. What's the result when you get a statute like that? Well, you get a lot of people coming from places like Florida and either moving or pretending to move to a place like Colorado. Public adjusters, the increase is over 1,000% in public adjusters over the last few years in Colorado. So most property damage policies have an appraisal clause. And this appraisal clause allows folks, property owners, to get verdict level money without getting a verdict. It's an ex parte investigation. There's no jury trial, no rules of evidence, civil procedure, no formal discovery, no cross-examination, no right to counsel, strict time limits, no reasoned decision, and they're rarely overturned. They have approximately the same finality as an arbitration award. So once it's entered, it's really hard to overturn. So the case we got called on this spring involved a townhome association, 50 buildings in a large city just east of Denver, Aurora, Colorado. There was a storm in 2013. There were 3/4-inch hailstones. Now, for those of you in Florida, that may sound big. It isn't. We get baseball, softball, we can get large hailstorms. This was not even listed in the registry of significant storms. The insurer, our eventual client, paid the hail damage, which is usually on things like roofs, not on what people claimed in this case, where they wanted windows replaced, and it turns out brick. Now, brick does not tend to have much impact from 3/4-inch hail. Public adjuster thought, nah, that $250,000 sounds a little low. Went almost to $7 million. So we had a little difference of opinion. Insured's law firm is retained, And then the insured, retained, and then they recommend a go-to appraiser. It gets into court. The federal court in Colorado, Judge Babcock, issued an order. He said the appraisers on both sides must disclose any known facts that a reasonable person would consider likely to affect his or her impartiality, including, first, a financial or personal interest in the outcome of the appraisal, and second, a current or previous relationship with any of the parties, including their counsel or representatives. The law firm must make every reasonable effort to ensure that the appraisal process proceeds in accordance with this order. The insurer made 4 requests for disclosure. They got letters back, one from the law firm. You know, we don't have any significant prior relationship with this appraiser. The appraiser writes a letter. You know, I do not have any substantial relationship with this law firm. This is, again, the policyholder's appraiser. So this is the appraisal clause in the policy. If we and you disagree on the value of the property, the amount of the loss, either may make written demand for an appraisal of the loss. In this event, each party will select a competent and impartial appraiser. The 2 appraisers will select an umpire. If you can't agree, then the court will appoint one. And the court appoints one based upon recommendations of lists from both sides. So here's how the law firms, and this is a national problem, how they rig the appraisal. So the insurer pays an amount it believes owed, in this case, $250,000. The public adjuster, retained by the policyholder, inflates the claim, and they're often paid on a contingency fee, contingent on the difference between what the carrier offered and what they recommend. In this case, that difference would be the difference between $250,000 and almost $7 million. Quite an incentive. The insurer scratches its head and said, you know, that's a pretty big delta. Doesn't seem fair. Law firms are hired. And then the plaintiff's policyholder law firm goes out and tries to hire a friendly appraiser. Then they try to obtain a biased umpire by misleading the court. Either get someone with no technical expertise or someone who might split the baby. The result is then an inflated appraisal order because 2 out of 3, so you got an appraiser on each side and an umpire, 2 out of 3. Well, guess what? If 2 out of 3 of them are good buddies, you're in trouble. If you've got the appraiser who's locked out of the discussions. And then in Colorado and several other states, the law firm files a bad faith suit based on the difference between the appraisal and the insurer offer. And in Colorado, again, 2 times. So the $10 million, what they came up with was $10 million, the umpire and the appraiser, for what our carrier client thought was a $250,000 exposure. So $10 million, and now they wanted to pile on and get $20 million plus the $10 million plus attorney's fees and costs. And that's when we were called. So the law firm, start with them. Their official blog preaches bad faith appraisal tactics. This is a Florida law firm. And I'm not using any of the names to protect the guilty. If the rule is there that there are no rules, I can get into the mud with the best of anybody. All I care about for my client is winning any way I legally can if we go to get an appraisal. Absent fraud, the courts in informal situations have just about blessed that anything goes. This is what I teach and preach to public adjusters that attend our workshops. Unlike an insurer to its customer, I have no obligation to be fair and act in good faith to the insurance company during the appraisal process. Win the appraisal any legal way you can because there is little likelihood of overturning a bad appraisal award. There is no second chance. Just win, baby, is the mantra every policyholder better have in an appraisal. This law firm obviously did not have ethics in their law school curriculum. The law firm's candid about its encouragement of bad faith tactics. Says, again, this is on their blog, many policyholder appraisals do not fully understand how to win the appraisal for the policyholders. Some may suggest that I am wrong and that the goal of appraisal is a fair number for both sides. Boy, imagine that. Getting the right umpire can make the difference between winning, having a so-so result, and getting killed because the fix is in. This is the real world of umpire shopping that goes on every day in the banter of the appraisal process. So the one in our case, we find out, and by the way, we're given 2 weeks to file an objection. We get the call, we've got 2 weeks. Judge is sick of the case, wants us to pay the $10 million, and we're not allowed any discovery. And this is common in the appraisal process. So we go out, put a team together, it's 24/7, and we start calling Florida contacts and lawyers, try to find out as much information as we can. Turns out this umpire has a a business address in Rockville, New York, in Denver, Colorado, and convinces the judge that he's local because of that Denver address. Judge says the court appoints blank as umpire, largely based upon the location of his business, its closeness to the subject property, parenthetically Aurora, Colorado, and the assumption that this closeness will give him a greater understanding of the loss in the context of the local area. And in the transcript, when he orders it, he is local. He is as local as all of you that are from other states. He's from Florida. He goes to courts and says he's local. He's got 5 addresses. And what are those addresses? They're UPS offices, P.O. boxes. Complete fraud. So, you heard about the $250,000, and then the public adjusters, $7 million, approximately, and then the appraisal award of about $10 million. So, we started with fiduciary relationships. Can we find in the public records any kind of relationships that these folks might have with one another, that the law firm and the appraiser that they selected? Remember, it's supposed to be competent and impartial. Well, let's start with an attorney-client relationship where the law firm represented the appraiser in 1995, and again in 1997, brought another suit for the appraiser. Well, that'd be newsy. Always like to know that a fair and impartial person is not being represented by your opposing counsel. Turns out the law firm incorporated for the appraiser, served as a registered agent. The attorney from the firm served as the business agent for 10 years. They were the registered agent for several years in Texas. So we got the attorney-client relationship. We're feeling pretty good. Well, I wonder if there's any financial relationships. We checked into that. So they have a fundraising relationship. They started FAPIA, which is a Florida Association of Public Adjusters. And they started in '93. Turns out the law firm was the only gold sponsor. Turns out that the appraiser was the president. Turns out, got an award. And these are our heroes here. Appraiser and a representative of the law firm. And FAPIA is not just a trade organization, it's a PAC, it's a lobbying arm to advocate for policyholders. There's nothing wrong with advocating for policyholders. Only if, but it is wrong if you're trying to say you're impartial. So we got a hold of the appraiser's marketing brochure. It includes a blurb from the law firm, a testament. Both appraiser and his staff have assisted me as well as my firm in resolving an untold number of large multi-million-dollar losses to an amicable resolution and settlement to the policyholder's benefit and satisfaction. Never disclosed. Law firm's website. For over 30 years, this appraiser has dedicated his professional life to being a voice for policyholders in property insurance claims. Today, he works as a public insurance adjuster. And another quote by the adjuster on the law firm's website. I was taught to always handle a claim as if my mama was the insured. I don't want an impartial appraiser who's thinking he's representing his mama. The appraiser believes it's his job as an appraiser to be somewhat biased. We found a transcript. Okay, what is your understanding of the meaning of the word impartial in the context of an appraisal? Answer, not dependent on others. Question, okay, would you consider within that definition to be free of bias or ill motives? Answer, no. I can't say that anyone serving as an appraiser in the role as an appraiser could ever be an advocate without being somewhat biased, or at least an advocate. The appraiser, we found a list, it's a partial list of awards. On the left are the initial awards, the original offers by the carrier. On the right are what he got. And I doubt if it's particularly readable there. But let me tell you that if he had a 10% contingency fee on this differential, it would be 11.3, 20%, 22.6, and 30% contingency fee would be 33.9. I'm talking millions. We also found out that he had 2 homes in Florida, one market value $4 million, one market value $8 million, and they're not that far from each other, if that makes a difference. And I'm sure any adjusters here are probably texting right now to figure out how to become a public adjuster in Florida. Appraiser serves as a law firm's expert witness. And we found multiple situations where they had hired this fellow, this impartial appraiser, so-called, as an expert witness. Now, this appraiser is exporting his business. He's gone worldwide. We found out through some contacts that he's in Christchurch, New Zealand now, with the stated goal of shifting the balance of power from the insurer to the policy holder. Another wonderful export of the United States to New Zealand, our litigation system. Court's ruling. Appraiser was misleading, understatement. Appraiser and law firm violated the policy in the court's order. The appraiser is partial and was not above board, and the court invited insurer to move for sanctions. That's an invite you always accept, right? We just received the order yesterday on sanctions. Found the insured's conduct impugned the integrity of the appraisal process in the court. Court ordered return of the $10 million plus $100,000 in interest for wrongful withholding. Found plaintiff's counsel acted in bad faith and ordered attorney's fees and costs against them, which will run well into 6 figures, in which we will be filing in the near future. Hopefully, this court case has actually gotten quite a bit of publicity, if it sounds familiar, because these people have been running this scam for a long time. So we want to let you know about it and be happy if you run across these characters or property damage situation to give you all the information we have. Thanks very much for your time and attention. Enjoy your weekend.